Well, welcome to Bianchi Law Talk on Facebook Live. It's great, as always, to give these informational videos. Guys, if you've been following me on Law and Crime, where I host 2 days a week for 3 hours at a clip, we've been covering this case, the Stanley Liggins case. Here's the decision. I wrote on it and was very prominently arguing during the course of this case how not to prosecute a case. That's what this case is about. Now, Stanley Liggins is accused of a very horrible and heinous crime over 28 years ago of raping and killing a 9-year-old girl and setting her on fire. He was convicted in 1993, and that conviction was reversed for prosecutorial misconduct by the introduction of evidence that was highly inflammatory on this very weak circumstantial case where many people for decades have believed Stanley Liggins was kind of railroaded. So that case had to be retried again, and in 1995, he was convicted for a second time. However, it was later determined 20 years later, over 20 years later, that the prosecutors had withheld, get ready for this, 77 police reports. 77, folks, on a very weak circumstantial case that had no DNA evidence, had no eyewitness testimony. It was basically, he was in the wrong place at the wrong time, he argues. And a court reviewed those 77 police reports and found at least 5 of them to have been highly exculpatory. In other words, the defense could have used those reports, in all likelihood, it could have affected the outcome of the verdict. So here we are in 2018, 28 years later, and Stanley Liggins is on trial again because prosecutors, instead of just saying this was so profoundly unfair, it was such an egregious violation of the rules that prosecutors are supposed to follow, which is to give all information to the defense, that they're not supposed to be the judge, the executioner, and the jury all in one thing, especially when that evidence tends to show a person may not have committed the crime. It's highly egregious. And here he is now standing trial 28 years later. What about a speedy trial? How can Stanley Liggins, even if he's guilty, get a fair trial under these circumstances? Prosecutors should have just dismissed the case, even though they'd have to hold their nose, as I like to call it, and said that justice is more important and prosecutorial misconduct should not have allowed this to occur. So while he is in jail for over 25 years in bankers' boxes somewhere in the police departments and prosecutor's office, laid 77 reports, many of which were exculpatory towards Stanley Liggins. Excuse me for a minute. Now, we may be a not guilty in this case. We'll find out. But my prediction is, even if there is a guilty verdict, and now this third trial 28 years later, it's my opinion that eventually a court down the road is going to say, you know what, prosecutors, you didn't do the right thing. We're not going to uphold this conviction. And it's a shame, because if in fact Stanley Liggins is the person who committed this crime, well, the victim's family is not receiving justice either by the manner in which this is going on. I see Mark D'Annunzio's on. He's in Italy, so I have an international audience. Thanks, Mark. Hey, I want to give you 2 quick cases that I handled as a defense attorney many years ago that I think highlight this rampant prosecutorial misconduct that is occurring, and why no one in New Jersey or in other places are holding prosecutors accountable for this is beyond me. There's a case, Brady versus Maryland. This is a United States Supreme Court decision all the way back in 1963 that basically tells you, without any doubt about it, all prosecutors know this case, you cannot withhold evidence that is favorable to the defendant. It is fundamental, a violation of due process to do so. So the 2 cases I handled, one was an attempted murder of a police officer, a shooting case in a bar where at a pool table, supposedly my client, who was in jail 4 years waiting for a trial, was alleged to have been the person who committed the shooting. Now, if you looked at all the police reports, I said as a defense lawyer, holy cow, how am I going to get this guy out of this? Or how am I going to be able to mount a credible defense, despite the fact he denied to me that he had anything to do with this? All the witness statements, all the police reports pointed towards him. It was going to be a tough case. And as I was getting ready to do opening statements in that case, a witness revealed to my defense investigator that there was an actual videotape of the shooting that had been provided to prosecutors 4 years earlier. I was in disbelief. I said, no, there can't be, because I don't have that in evidence. It's a highly relevant thing to have a videotape of the shooting. And so I went to the courthouse, yelled and screamed, and eventually the prosecutor admitted they had the tape, but their argument was that the tape didn't have anything exculpatory on it, or in other words, favorable to the defendant. Hey, my argument was to the prosecutor, it's not your job to determine what may or may not be exculpatory. You don't know what my defense is. You don't know what my client is telling me. You should provide that tape. And they actually fought against releasing the tape, but eventually, of course, the court ordered, no, that's a relevant piece of evidence, turn it over to Bianchi. And you know what that tape showed? That my guy was wearing a yellow jacket, and it was as clear as day on the tape when the scuffle starts at the pool table where the shooting ultimately occurs. My client actually runs out of the bar, and another camera from outside the bar captures him standing outside the bar when you see flashes, that is the gun going off at the pool table. It was obviously extraordinarily exculpatory. Why a prosecutor would do something like that is beyond me. But you know what the repercussions were for that prosecutor? Nothing. Nothing occurred. No ethics complaints, no review by the prosecutorial section of the Attorney General's office, nothing. Another case I want to highlight is one in which I was trying a murder case as a defendant, and my guy was saying all along he did not commit the murder. And then eventually I had asked the judge to release all of the criminal case histories of all of the witnesses. And the judge basically refused to do that and said, essentially, if the prosecutor has information of prior convictions or open charges against a witness, which is clearly cross-examinable during the course of a trial, it's called expectation of benefit. That is, the person's expecting a benefit for testifying favorably for the prosecution, that they'll turn it over. I was told that no witness had any criminal conviction, which was odd to me because there were a lot of witnesses that testified in that case. Well, one of the last witnesses got on the stand and said something that I had never heard before. I was blindsided by it completely. I made my objections known to the court. The judge refused to dismiss the case based upon that. He said basically the prosecutor just failed to turn it over, and I'll give you a day if you want to confront the evidence. I said no. I did the best I could on cross, and then I made a motion at the end of the case to dismiss it because there wasn't enough evidence to prove that he committed the murder. And the judge actually said, you know what? I would have dismissed it if it wasn't for that last witness and what that last witness said. Now, remember, I was never given any criminal case histories because the judge refused to have it produced and ordered the prosecutor to give me any data about prior convictions. I go into the jail cell where my client is being held, again, another guy who's been held in jail for years, and he tells me that that witness has all sorts of convictions and for robbery and theft and drugs, and in fact has open charges in the county. I'm like, I don't believe that, because we made a big deal about this. The prosecutor was required to turn any of that data over to me. I went to the prosecutor and I then asked them, listen, can you at least let me see the criminal case history for that witness? And they did. And boy, I couldn't believe what I saw. There had to be 15 pages of previous convictions, about 6 or 7 open charges that that very prosecutor's office was prosecuting. And then the prosecutor lands on me that while she was actually testifying in court that day, and now her testimony is completed, we're getting ready for summations, she was actually under arrest because I had noticed there was a failure to appear in court. And he said, oh, yeah, well, she was locked up on that and she was under arrest when she testified. This is highly cross-examinable material. Just trust me when I tell you this, folks. The case law is clear on this, that defense lawyers can cross-examine because that witness has an expectation of benefit for testifying favorably for the prosecution. When we eventually went on the record with this and I told the judge what had occurred, the judge was so outraged, he actually dismissed the murder case, the murder charge, right on the spot because, again, the only basis upon which he kept that weak case together in the first place was because of that woman's testimony. He had had enough, the judge. So at the end of the day here, the judge asked the prosecutor in that particular case, why did you withhold this from Mr. Bianchi? And you could have knocked me off the chair with a feather when the prosecutor says, because I knew he would use that to cross-examine my witness, harm the witness, and likely I wouldn't get a guilty verdict. Well, that's exactly the reason you're supposed to turn it over. Folks, bottom line here, whether it's the Stanley Liggins case, or the 2 cases I mentioned, I have witnessed in my career multiple instances of prosecutorial misconduct, and unfortunately, many times done purposefully, and nothing ever happens. The Supreme Court and the Attorney General's office continue to say that they're going to take this seriously, but until they do, and until somebody gets spanked, this kind of thing is going to continue. And if you're a believer in justice and you're a believer in playing by the rules, and in fact, whether or not innocent people are wrongly convicted of crimes, this is something that I think this public should be in an uproar. Our public should be in an uproar about. You wouldn't want it to happen to you, and it shouldn't happen to anybody. It's against the rules, and nothing gets done. So, folks, listen, I always appreciate if you could share this video. I hope it was informative for you. And every Sunday at 10:30 on Bianchi Law Talk Live, you can join us at 10:30. And also, if you could subscribe to my new YouTube channel at Robert Bianchi ESQ, it would be greatly appreciated. And again, thank you for all the support and for the Bianchi Law Group. Any family or friends that are ever in need of criminal defense attorneys, myself and my partner David Bruno are both certified criminal trial attorneys by the Supreme Court in the state of New Jersey, and it would be our honor to do so. So I see Chief Paul Williams on, and Julio. Thank you guys, and Mark, for all of your support. And we'll be seeing you next week with another updated legal topic. Hey, this week's going to be hot on TV, where I know we're going to be doing a lot on the Manafort plea and the issues with that. So you can also watch my live TV hits that I always post on my YouTube channel as well as Facebook Live. Have a great week, guys. Bye.